emphasize that we cooperated very strictly, I think, about the Polish Constitutional Court and the Lithuanian Constitutional Court under Mr. Žalimas. This was the very strict relationship, especially between Andrzej Rzepliński as the president of the Polish Constitutional Court. Next speaker will be Domnica Manole. Domnica Manole is a president of the Constitutional Court of Moldova in Chișinău. So I remember very nice our cooperation between Polish Constitutional Court and Moldavian Constitutional Court, especially under the presidency of Alexandru Tanase. And I think that Domnica Manole is a successor of President Tanase. Next, Serhiy Holovaty, today is not participate in our meeting. Next, those are our colleagues from different Central European countries. So this is our colleague, our friend, Alexander Bröstl. Alexander is a professor of University of Košice and former judge at the Constitutional Court of Slovakia. And I would like to add that Alexander is a very famous theorist, philosopher of the law in our region. I met him first time in the 90s in Poland, and I would like to emphasize that Alexander is a guardian of Gustav Radbruch thing. Next will be Alan Bronfman from Chile, a professor of the Pontificia Universidad Católica de Valparaíso, Chile. Nice to meet you. And next, our speaker will be Toma Birmontiene from Lithuania. Toma Birmontiene, I met her in Poland and Lithuania because she was as a judge at the Constitutional Tribunal in Lithuania, and now Toma is a professor at the Nicolas Romeris University in Vilnius. And next, this is Pablo Saavedra from Chile. Pablo Saavedra is executive secretary of the Inter-American Court of Human Rights, American University Washington College of Law. So that's all as regards us. Once again, I would like to thank for Konrad Adenauer Foundation. Thank you, Mr. Rank, especially for you and especially for Rainer Arnold. This is a pleasure to us to be with you here. And I would like to add that I very appreciate the collaboration with the Adenauer Foundation, especially in Poland in the 90s, because your foundation supported the Polish transformation in the 90s, and I met a lot of people for your foundation in Poland, in Warsaw, and this was very vital for me, cooperated with Adenauer Foundation. So that's all as regards our opening remarks, opening session. So, Gloria, the floor is yours, please.
Buenas tardes ya. Un agradecimiento a los organizadores del evento. Un saludo cordial a mis compañeros de panel. Muchas gracias por la asistencia. En este panel de inicio, como panelista de inicio, quiero recordarles que nos ocupará establecer algunos acercamientos a cómo han atendido estas situaciones de emergencia en los estados constitucionales. En Colombia nos encontramos en una época de dogmática, de grandes elaboraciones importantes en el derecho constitucional. Cuando aparece en nuestras vidas, irrumpe un fantasma peligroso que no vemos, pero que existe, que nos cambia sustancialmente la vida, que nos pone nuevamente a lo más elemental. Nos impide los abrazos, nos impide salir de la casa, nos hace obligatoria la distancia a pesar de que nos acostumbramos a querernos y abrazarnos. ¿Cómo pueden los jueces constitucionales enfrentar posiblemente las restricciones más evidentes de los derechos que dogmáticamente habían tenido unas elaboraciones interesantísimas, pero que ahora, en aras de defendernos frente al fantasma, tenemos que buscar la forma de restringirlos? Preguntas elementales, pero sin embargo de muy difícil aplicación ya en la práctica. ¿Hasta dónde, en el caso colombiano, el presidente de la República puede impedirnos hacer lo más elemental de nuestras vidas, como salir de las casas? Para contarles nuestra experiencia en el Tribunal Constitucional colombiano, yo quiero dividir esta corta charla en dos puntos. La primera, hablar con ustedes de cómo respondió el Estado colombiano a esta situación extraordinaria. En esa medida, cómo respondió normativamente y el Tribunal Constitucional, ¿qué dijo frente a eso? El segundo punto, muy rápidamente, mostrarles los retos en los que hoy el Tribunal Constitucional colombiano se enfrenta. La Corte, a través de la acción de tutela, que son los estudios de los casos concretos, tenemos que enfrentarnos a las situaciones de personas, particularmente hablando, que invocan la protección y la eficacia de los derechos fundamentales. En el primer punto, la Constitución del 91, en buena hora, autorizó la expedición de decretos en estado de emergencia económica, social y ecológica. Y haciendo uso de esa facultad, el presidente de la República expidió en su momento 115 decretos leyes, expidió 115 leyes para establecer unos límites al ejercicio de los derechos y otras garantías de protección. A la Corte Constitucional le corresponde el control constitucional de uno por uno de esos decretos. Un dato curioso: en vigencia, o bueno, bajo la presidencia anterior y en época de normalidad, durante 8 años, la Corte revisó 54 decretos de emergencia y en 2 meses, 10 días, la Corte Constitucional tuvo que revisar 115 decretos con fuerza de ley. De esos 115 decretos, analizamos 885 artículos que constituían la base legal para efectos de establecer los límites en época de pandemia, límites y garantías en época de pandemia. La sentencia C-145 del 2020 declaró la exequibilidad de ese estado de emergencia, que a pesar de que contenía una gran cantidad de restricción de derechos, se entiende a través de la ponderación de los mismos que era una restricción constitucionalmente válida en la medida en que tenía como fin la protección de unos intereses constitucionales de mayor peso, como por ejemplo la salubridad pública. Por esa razón, la Corte entra a hacer el estudio de estos decretos y declara a pesar de que su jurisprudencia había sido una jurisprudencia estricta y un control constitucional rígido cuando se trata del control constitucional de las normas expedidas por el presidente de la República en estados de excepción, aquí la Corte asume una posición totalmente distinta y directamente explica que ejerce un control flexible, un control mucho más atenuado, propiciado por una situación que antes nunca se había presentado. Le reconoce al presidente de la República una función judicial, una función legislativa amparada por una situación de emergencia absolutamente extraña en nuestro ordenamiento jurídico. A pesar de este control flexible, la Corte Constitucional declaró 7 de esos decretos legislativos, los declaró inexequibles y los retiró del ordenamiento jurídico. Un control constitucional flexible, atento a las circunstancias, pero evidentemente preocupado por mantener el principio de supremacía constitucional. Una Corte Constitucional que, a pesar de que reconoce este desequilibrio en la separación de poderes, a pesar de que le reconoce al presidente de la República un margen de apreciación importante, preocupado por la eficacia real de los derechos. Y en esta segunda parte les muestro cómo el Tribunal Constitucional en Colombia empieza a analizar las situaciones concretas y empieza a mostrar que, a pesar de la situación de excepción, a pesar de la flexibilidad que le reconoce a los órganos políticos para tomar medidas en época de excepción, a pesar de ello, muestra que la función principal del Tribunal Constitucional sigue siendo el control al abuso de poder y sigue siendo la eficacia real de los derechos fundamentales. Miren estos casos tan interesantes que la Corte ya ha tenido la oportunidad de pronunciarse. En temas de contratos laborales, en época de excepción en donde se reconoce que los empleadores pueden suspender los contratos laborales y que incluso en los decretos que facultan a los empleadores a suspender los contratos sin salarios, a prorrogar o a acudir a las vacaciones no solicitadas por los trabajadores, aún en esos casos se presentan situaciones como, por ejemplo, la de una persona que tenía o tiene cáncer y por su situación del cáncer le impiden el ejercicio de su contrato laboral. Le dice el empleador: señora, a usted le tenemos que proteger porque el cáncer es una morbilidad en el COVID, pero mientras la protegemos, la dejamos sin trabajo. La Corte estudia el caso y les dice: la posición de protección no puede impedir el ingreso para sobrevivir. Sentencia 187 del 2001, un fontanero, un trabajador en una mina que también le suspenden y le terminan su contrato laboral porque en época de pandemia se disminuyen las actividades en la mina. Pero sin embargo, este trabajador tenía una enfermedad conocida por el empleador, que de hecho el empleador le había cambiado algunas actividades para poder hacer compatible la protección al trabajo y el ejercicio de sus labores, y le suspenden con ocasión del argumento de la disminución del trabajo en las minas. ¿Ya? Bueno, casos múltiples en la Corte muestran que también, al igual que la importancia de los abrazos, el Tribunal Constitucional tiene que volver a lo elemental. Y lo elemental del Tribunal Constitucional es proteger la supremacía constitucional, la eficacia de los derechos humanos y el control al abuso de poder para fortalecer la democracia. Aún frente al fantasma, la democracia y el Estado constitucional debe prevalecer. Muchas gracias.
Many thanks, Gloria, for your interesting presentation. You raised a lot of problems typical for different countries, among others Poland and Central European countries. Thank you once again. So now we have next presentation, but this will be online presentation, yes? We have the link with Dainius Žalimas. I would like to ask Sebastian, our IT engineer. So I have information that in this moment we have the link with Domnica Manole. Domnica Manole, once again, I would like to emphasize it that this is the president of the Constitutional Court of Moldova. Domnica, the floor is yours, please.
Thank you. Dear colleagues, since 2019, we are living a period of crisis whose effects and duration are yet unknown. It is not only a crisis at the national level, it is also a crisis of the global level. The COVID-19 epidemic still continues, and I think we all want it to disappear. We want to return to a life without prohibitions such as the ones currently in place. Most constitutional courts and supreme courts in the world have faced cases where laws of parliaments, of measures, of executives related to emergencies are challenged. With the outbreak and spread of this epidemic, the Constitutional Court of Moldova has resolved same applications. I will mention two of them today. In June 2020, several MPs of the Republic of Moldova challenged the amendments to the law on the state of emergency adopted in connection with the pandemic situation caused by COVID-19. The applicants mentioned that the amendments to the law broaden the spectrum of measures that can be applied during the state of emergency. The law provides that the authorities empowered to administer the state of emergency may exercise other necessary duties when those expressly provided for in the law on the state of emergency. According to the applicants, the formula of the necessary duties was unclear. It gave disproportionate power to the authorities responsible for managing the state of emergency via the unlimited margin of discretion it is established. The court noted that the use by Parliament of such general formula is indispensable in the field of urgency. The authorities responsible for managing the state of emergency need flexibility to be able to react promptly to various emergencies that may endanger the country. A detailed and anticipated description by Parliament of the measures that may be needed to combat the state of emergency is a difficult or even impossible task. Also, the use of rigid wording or a comprehensive description of measures may limit the capacity of the executive branch in emergency situation. However, even though Parliament used more flexible wording to describe the contested provisions, the court emphasized that this itself does not give the executive absolute discretion. The executive remains limited in choosing the emergency measures because Parliament used the word necessary. The term necessary means the adoption of proportionate measures. However, in order to avoid abuse, guarantees are needed to reconcile the balance of power in the state on the one hand and the need to ensure public safety on the other. First, the court observed that the authorities responsible for managing the state of emergency can carry out the duties under the said law only during the declaration of the state of emergency. Therefore, the powers established by the contested provisions are limited in time. Second, the court noted that by their nature, the authorities responsible for managing the state of emergency are part of the executive branch. Thus, the powers of the authorities responsible for managing the state of emergency are limited by the reasons and objectives that were the basis for declaring the state of emergency and cannot exceed the competencies of the public authorities established by the Constitution. Thus, the contested provisions have a limited, concrete, and strictly functional scope. Third, the court mentioned that it is essential for people to have an effective remedy in the event the public authorities violate human rights instituting emergency measures. In this respect, the court noted that the decisions of the authorities responsible for managing the state of emergency can be challenged in court in administrative litigation. However, the administrative code limited the power of judges in the verification of the legality of emergency measures.
Dominica, hello, Dominica. Sorry,
Yes.
we have the rules of 7 minutes.
I'm sorry.
Maybe last note, last remarks, yes?
The pandemic has been a challenge for us, the judges, and at the same time it has brought us the satisfaction of effectively guaranteeing human rights even during exceptional situations. Thank you for invitation.
Thank you so much, Dominica. Very interesting presentation from Moldova. It's appeared to me that this is the example when, during the pandemic time, the constitution was amended by the legislator. And the legislator in Moldova adopted new disposition in the constitution against the pandemic. And Dominica emphasized that this was the very large spectrum, the measures. So next, our next speaker is Alexander Bröstl. Alexander, the floor is yours, please.
Thank you very much. Ladies and gentlemen, señoras y señores, salud para todos. I would like in brief, first of all, thank very much Rainer Arnold, my old friend, for the possibility to speak here, Konrad Adenauer Stiftung, and also colleagues from Colombia, and my co-author, the former judge for 19 years, Ludmila Gajdošíková, who helped me to create also this presentation. I have 6 minutes left, so I will try hard. I will just structure problems. It is not a paper. Real paper will be in a written form, I hope, which will focus on answering these questions. So the first thesis is, and you may oppose it, but this is discussion. The rule of law is a principle of democracy. This is point 1 of my thesis. Point 2, the enforcement of the rule of law requests judicial review. This is the modern, let's say, and the transitional constitutionalism thesis. The judicial review of constitutionality of statutes and maybe also constitutional amendments or constitutional laws. This is a question. How far should the protection of constitutionality reach? The third point is that because I should reconsider basic, I'm going to do it, basic concepts, including 3. It means democracy. It sounds very strange. What is democracy? What is the rule of law? And what is Kelsen's pyramid? Good for what? It's a very critical attitude, maybe, but what is democracy? We didn't read Aristotle thoroughly, because what we have in his structures, I mean the regular and irregular forms of government. I underline government, and arche and kratos. Surprisingly, we would come to a conclusion, maybe, that what we have now is a regular form, according to Aristotle, politeia, which is composed of democracy and oligarchy. This needs more analysis. Then, from the point of view of the rule of law, that's Plato. Plato, that law should rule instead of people. it's ideal. It's impossible, because if law is interpretative, constitutional, so you will never reach democracy without democrats and the rule of law without excellent lawyers, so to speak, if it's a professionalized now. Then the Kelsen pyramid, it's in a few underlinings. It's a critical topic at the moment because it's far from maybe true. The pyramid structures, maybe it is like Triglav, 3 tops of the pyramid. But you could come to another conclusion. I would just underline, it's more horizontal than vertical, as we would think. And this needs a rethinking of the idea. I mean, also from the point of view of the European rule of law, which is another point, because now we know that the renegades, Poland and Hungary, have been punished. Yes, there are sanctions foreseen because of violation of values, basic values, the rule of law, human dignity, etc. But I'm not, because I mentioned these 3 points, democracy, rule of law, and this Kelsen's pyramid. It needs more discussion and better solutions. And I'm coming to the point, European law of law and separation of powers. Is it goodbye Montesquieu a long time ago? And it is more sophisticated maybe. And then this is the last point. I would like to focus on the judiciary, independent judiciary, and come back again to the constitutional review or to the judicial review. As I'm surfing throughout history, and this is one step backwards now, I would think that the solution also in Aristotle, and we can discuss with Friedrich von Hayek about demarchy, if Aristotle has been a little bit not correct in this point, but I found the 3rd point, and this is the solution in my opinion, because we have these nice English words, government, and the Spanish word, for example, gobierno. So this is the solution because in my point of view, it needs more evidence and arguments, because kubernoi is a ancient Greek word, and maybe this is the generalization, this is the top of, or the common point for this generalization between kratos and arche, because it is cybernetics, and this is how to find the point. It's like administration of ruling, but not in this strong sense. It is a variety. Kratos and arche are varieties of this kybernoi. I overstepped, but the last point is, and I will finish here, the judicial review is worth to revise because Emmanuel Siaye, a noble thinker, excellent one, it is very well known about his division at the revolutionary time, but also after, between pouvoir constituant and constitué. But it is less known, his constitutional jury, these ideas about constitutional jury on Thermidor 1794 and 1795. And these are very excellent ideas, but it was impossible to introduce it after the discussion in the convent. It was not the right time. And I will finalize it here. If we follow, because of the sovereignty of the parliament, I would say that time, the strong parliament, the sovereignty of the people, and so on, and this that time, this judicial review was not at place at time, the idea. It comes later and ended in the Conseil Constitutionnel and in preventive control. And my question is now also for European countries, because the old, ancient question it is a very old question. Who is Kyrion Panton? Who is the master of everything, of all? And this relates and goes back to the relationship between Ecclesia and Dicasterion. It's very clear, and it depends. At revolutionary times like this, judicial control is not at France at that time, but later on, after World War II, for example, very strong. This was becoming a necessary body to protect. Now, and this is really the last point, do we need a constitutional court after, let's say, establishing normal form of government, including courts, from ordinary courts to the Supreme Court, dealing with protection of human rights and freedoms. So, but it needs more discussion. Thank you very much. I overstepped a bit the time, but thank you very much for your attention.
Thank you. Thank you, Alexander. It seems to me that we can see that Alexander, this was the track of the spirituality of our colleague as a thinker, as a philosopher of the reviewing of the constitutionality of the law. And obviously the question of the preventing control, preventing checking, it is said in Polish literature, a priori control is very vital and very interesting, and you appreciate this control, I think. So thank you once again, and I would like to ask our IT engineer Sebastian, we have the President Žalimas? No? Thank you. So now I would like to ask our colleague Alan Bronfman, professor at the Pontificia Universidad Católica de Valparaíso, Chile. The floor is yours. Please.
Muy buenas tardes. Agradezco a Miroslaw, a César, al profesor Arnold, esta invitación a la organización del evento. Intentaré ajustarme al tiempo previsto. El gobierno constitucional, la idea del constitucionalismo es limitar el poder a través de leyes escritas. Esa es su premisa, leyes abstractas elaboradas con anterioridad a las situaciones que son objeto de regulación. Como es claro, especialmente en estos momentos, es evidente que la ley escrita puede no ser adecuada, idónea para resolver situaciones que afectan valores e intereses fundamentales de la comunidad y que denominamos anormalidad o emergencia. La variedad de estas situaciones de anormalidad o emergencia es extensa, es muy heterogénea. Por supuesto que estamos marcados por una situación sanitaria que nos sugiere una serie de respuestas, pero junto con este tipo de problemas hay otros que son impensables y probablemente en el futuro tengamos que sufrir anormalidades o emergencias de muy distinto tipo. Hace muy poco un buque encalló o tuvo un problema de tráfico en el canal de Suez y eso generó una enorme cantidad de emergencias en distintos países, ¿no? Lo típico de estas emergencias es que requieren una respuesta particular. Cada emergencia requiere una respuesta particular. Y esa respuesta particular es posible que esté fuera de las competencias previstas en esta ley elaborada con anterioridad. Y con frecuencia va a estar fuera de estas respuestas. Por otro lado, esta respuesta anormal que exige poderes extraordinarios debe gozar de legitimidad política y social. Si estas respuestas realizadas a través de poderes extraordinarios carecen de esa legitimidad, simplemente no van a poder ser implementadas porque no hay posibilidad de cumplimiento forzoso o ese cumplimiento forzoso está muy distante. La legitimidad en las democracias liberales tradicionales está fundada en reglas de carácter formal, en una ley establecida a través de un procedimiento que entendemos representativo, que es la base de la democracia contemporánea, y ese procedimiento básicamente se reconduce a la elección de autoridades. No hay una legitimidad más sustantiva que no diga relación con ese procedimiento formal de elaboración de la ley de acuerdo al parámetro o al estándar constitucional. En situaciones de emergencia, esto conlleva a respuestas que son básicamente formales en el sentido de adoptar medidas dentro del marco de la legalidad. El patrón o la medida de control es el ajuste a la legalidad, y ese ajuste a la legalidad, como digo, está fundado en elementos formales. Si la medida adoptada está dentro del estándar de legalidad que esté en la ley, que esté en una norma, en un estado de excepción constitucional o en la interpretación de la ley, se entiende que esa medida es adecuada. Esto normalmente nos aleja del análisis sustantivo de las medidas. La primacía de esta mirada formal sobre estas categorías aleja, distancia el análisis sustantivo que ellas debieran tener, porque, repito, el fundamento de la legitimidad en la democracia liberal es fundamentalmente este procedimiento formal de elaboración de la ley, cualesquiera sea su contenido. Frente a esto, y yo voy terminando, hay dos opciones: control político y control jurídico. El control político normalmente está exhibiendo problemas que tienen relación con problemas del sistema político, problemas que tienen que ver con la representación y con los propios partidos políticos. Ahora bien, el olvido del control político genera enormes problemas porque tiende a recargar al control jurídico. Y en este sentido es que mi reflexión es que las situaciones de anormalidad o emergencia, dentro de los cánones previstos por la Constitución, tienen que ser sometidas a una supervisión política intensa. Que esa supervisión política no se haya desarrollado, sea insuficiente, incompleta o adolezca de problemas, no puede ser obstáculo para que ella no se desarrolle. Si este control no se desarrolla, recargamos a la jurisdicción constitucional con unos deberes y unas actividades y competencias que están fuera de su ámbito natural de actividad. El control jurídico tiene que desarrollarse, y en el caso de la jurisdicción constitucional, a partir del análisis del efecto, del impacto de las medidas adoptadas sobre derechos y libertades individuales. Creo que la herramienta más adecuada es el control particular, el control que denominamos concreto, porque ese es el control que puede enriquecer en el futuro el desarrollo de estas potestades extraordinarias, de estas potestades de emergencia. Si el control jurídico se desarrolla ante la ausencia de control político de manera excesiva, estamos dañando, estamos menoscabando, estamos afectando el desarrollo de ese control de carácter jurisdiccional. El equilibrio, el complemento entre el control político y el control jurisdiccional es esencial. Repito que las dificultades que pueda observarse en el ejercicio del control político no pueden ser superadas simplemente con un reforzamiento indiscriminado del control constitucional, porque a su vez podría dañar una legitimidad que es imprescindible para el buen funcionamiento de las medidas en estados de anormalidad y de excepción, ¿no? Eso es lo que quería plantear. Estoy dentro del tiempo, ¿no? Sí.
Thank you so much for your very interesting presentation. Thank you, Alan. And now, this will be the next presenter, but in the online format, yes. So I would like to welcome our colleague from Lithuania, Professor Toma Birmontiene. Toma, the floor is yours, please.
Hello, Miroslav, thank you very much. Do you hear me? Is it okay, the communication? So dear colleagues, it is rather complicated. And the time is very complicated that we are living through. And of course, this Congress, we all expect it to be alive and we all expect it to be together. At least it is very nice that this Congress takes place and some of us are in a distance, but I'm very happy that so many colleagues could participate live. And maybe this is one of the biggest and challenges and one of the biggest value of our Congress. The title of our panel is of course very difficult because we have to decide and we have to speak about the constitutional jurisdiction, rule of law in time of emergency. But even discussing this subject, we have to agree on the concept because the emergency we, in all our jurisdictions, we have different attitude to the emergency regime. Because in one country it is a curfew, in another country it is a quarantine. So there are a lot of different variations of the emergency regime. And again, emergency regime implies some kind of a threat. Sometimes we can see the threat from outside, maybe some conflicts between the countries, maybe some problems inside the country, inside the state. But in this case, we have to fight the virus. So this is absolutely a novel situation. And in that new situation, the constitutional courts have to give the answers. And those answers have to be given in difficult fields. If you just look through the decisions of the constitutional courts, and many constitutional courts, even in Europe and in many other parts of the world, have adopted some decisions. So these all decisions, of course, mostly are speaking about the restrictions of human rights and the problems that the pandemic, during the pandemic, some restrictions have to be held. But the problem is whether these restrictions are in line with the Constitution. But our Constitution didn't expect any pandemic. We do not have any clauses. We do not have any articles. We have only article for the protection of health. And in this situation, the constitutional courts and the whole society is in a very, how to say, strange situation. Because from one side, we have to protect the health, and we have to protect the right to health care. From the other side, if we want to protect the right to health care, we have to make some kind of restrictions. So health as a value, as a constitutional value, on the same foot, at the same time, is an individual value, and of course is a value of a society. In this situation, of course, constitutional courts have to give the answer, and just to see the situation a little bit from the different angle. The emergency situation and the situation, the pandemic situation, shows that now we are living in a situation of the shifting of powers. And shifting of power, first of all, we can speak about parliament and the government. Who has the powers? Yes, on restriction of human rights. We all know that from the classics, from the classical doctrines. Of course, the parliament has to adopt the decision. But sometimes we are dealing with such an emergency situation that government takes some actions, and in some cases the parliaments are very slow and very late. So the constitutional courts would have to decide that in a state of emergency, when you have to adopt a different decision, maybe the shift of the power to the government in some cases could be constitutional, though in other situations, of course, not. Another shift of the powers, we, as a constitutional doctrine, we always try to protect individual. The individual and his rights are very, how to say, easy to, sometimes it's easy to violate these rights. But now we have little bit different shift. When we see the rights of individual and the rights of a society, sometimes we think that rights of the society, so the protection of the society sometimes is, so the power or protection of the society is shifting to the tallest interest of the society. And in this case, we also have to decide many questions. Constitutional courts are dealing with vaccination problems, whether it's mandatory or just optional. And of course, now green passes, and Lithuanian Constitutional Court is also in line to decide that case regarding the green passes. So the state of emergency and the situation that we are living, it's a very great challenge for the constitutional courts and for the constitutional doctrine. I think that maybe next time, during the next Congress, we will have much more clear picture, and we will see how constitutional doctrine will be developed by the constitutional courts, bearing in mind the state of emergency and of course the problems that we are dealing with. So the role of constitutional courts is not only very special, but very important, because this is the arbiter between in the different political situations. So in this case, I would like to stress, coming to the end of my short presentation, that independence of the constitutional courts is essential. In this situation, if the courts are empowered to adopt independent decisions, if they are not just a part of a political power, or not just a part of a, not in the hands of politicians or some even other interest groups. So it is very important for the constitutional courts and for us, for the society, for the rule of law, to protect the independence of constitutional courts that in some countries we know, and even European countries, now constitutional courts in some countries are of course facing a lot of challenges. So thank you very much for this opportunity to share some thoughts. Thank you.
Thank you very much, Toma, for very interesting Lithuanian perspective on the constitutional time during the emergency situation in the constitutional law. I share your point of view that this is completely new situation in the constitutional law and for judges, for justices. So last but not least, obviously, is Pablo Saavedra from Chile. I would like to ask our colleague, we have, yes, the connection with Pablo. Pablo, the floor is yours, please.
Buenas tardes, ¿me escuchan? Sí. Buenas tardes, es un gusto poder compartir con todas y todos este espacio y agradecer a la Fundación Konrad Adenauer por este espacio de reflexión que nos están otorgando a todos desde diferentes perspectivas para analizar el impacto que ha tenido el COVID. Quizás yo voy a dar una aproximación diferente, que es qué hizo la Corte Interamericana de Derechos Humanos en relación con el COVID. Para quienes no son de nuestro continente, la Corte Interamericana de Derechos Humanos es el equivalente a la Corte Europea de Derechos Humanos, la Corte de Estrasburgo. Y en este contexto lo quiero dividir en dos aspectos. Una declaración que emitió en abril del año pasado la Corte Interamericana de Derechos Humanos y una medida provisional urgente y rápida que tomó en relación con COVID y migrantes. Respecto del primer punto, a inicios de abril, cuando recién se estaban empezando en nuestro continente a cerrar las fronteras, ya estaba el COVID presente y había una incertidumbre completa en la región sobre qué hacer, cómo abordar el tema de COVID. De una manera inusual, la Corte Interamericana adoptó una resolución llamada COVID y Derechos Humanos, Problemas y Desafíos, que deberían ser abordados desde una perspectiva de derechos humanos. Esto para un tribunal internacional y como la Corte Interamericana no era habitual, no emitimos declaraciones. ¿Pero por qué se hizo esto? Porque veíamos que las diferentes voces que estaban aflorando, al menos en nuestro continente, sobre cómo abordar el tema COVID, no lo estaban abordando de una perspectiva de derechos humanos. Y la Corte puso énfasis en ese aspecto. Esto es un problema de derechos humanos y hay que desarrollarlo con políticas públicas en enfoque de derechos humanos. Y es curioso, si uno lo ve, esta declaración desde inicio, como digo, de abril del año 2020, los diferentes puntos que fue abordando la Corte Interamericana en esa declaración, que lo voy a decir de una manera muy sucinta, son las grandes problemáticas que nos enfrentamos hoy y creo que han sido abordados por los diferentes tribunales, si uno lo ve de una perspectiva comparada. Primer punto que llamó la Corte y dijo, esto no es un tema nacional, sino aquí es un tema global y tiene que abordarse de una manera multilateral. Después dice, todas las restricciones que se adopten para restringir derechos deben hacerse de una manera proporcional, ajustada a la ley, de acuerdo a la necesidad y con la mejor información que se tenga al respecto. Después puso énfasis en todos los aspectos económicos que se estaban viendo en ese momento, se percibían el pleno respeto a los derechos económicos, sociales, culturales y ambientales. Ese fue otro de los temas observados. Otro de los temas que en nuestra región tenía mucho impacto, los temas de privados de libertad y COVID. Cuidado, que aquí hay que tomar medidas especiales por las primeras señales que se estaban viendo por la sobrepoblación carcelaria. ¿Cómo se resaltó el tema mujeres y COVID? El impacto diferenciado que esto iba a tener en las mujeres, especialmente en los casos de violencia de mujeres que venían en la región. El rol, desde otra perspectiva, el acceso a la justicia y el rol de los defensores de derechos humanos y periodistas y enfatizar la importancia del acceso a la justicia sobre la materia. Esos son algunos aspectos de esta declaración que adoptó la Corte Interamericana y que tuvo un gran impacto en la región y fue adoptada por diferentes tribunales para dar un enfoque de derechos humanos en sus diferentes decisiones. Por razones de tiempo me voy al otro punto que creo que es una experiencia desde el punto de vista jurisdiccional importante. En el marco de una supervisión del cumplimiento de sentencias que teníamos, nosotros supervisamos nuestra sentencia a diferencia del Tribunal Europeo, se nos solicita una medida provisional, que es para actuar en casos graves, urgentes y cuando estemos en presencia de un daño irreparable. Y nos encontramos con una situación en mayo del año pasado que en el sur de Panamá, en la zona del Darién, donde confluyen los máximos movimientos migratorios de nuestra región, inmigrantes en situación prácticamente de pobreza, es decir, de un momento para otro se le empiezan a cerrar las fronteras y dentro de Panamá cordones sanitarios. Y donde habían albergues de migrantes, donde podían haber 50 personas, de un momento para otro se encuentran más de 2.000, 3.000 personas hacinadas y sin ninguna perspectiva. Y la Corte dicta una medida que ha tenido un gran impacto en la región y después ha sido recogida en otras partes, dice, Estado, usted como garante tiene que tomar medidas especiales al respecto. Medidas de salud. Todos los temas de distanciamiento social. Lleve agua, porque el sector es muy pobre. Lleve médicos. Atención especial a las mujeres embarazadas, a los niños, etc. De un albergue adecuado ¿Y qué llevó esto? Y esto es un problema que hizo un llamado a las diferentes agencias de cooperación internacional, produjo una movilización de los diferentes actores y llevaron, en este caso a Panamá, a adoptar diversas medidas sanitarias, económicas, de salud, etc. Y ahí tenemos, posteriormente, y con esto voy concluyendo, en este año haciendo supervisión de esta medida que estaba siendo exitosa, nos encontramos a una nueva problemática, el acceso a la vacuna. Y la Corte dicta y complementa esta medida, dice que no se puede discriminar en el acceso a la vacuna para el COVID en relación al estatus migratorio. Y esto posteriormente ha sido recogido por varios tribunales en la región. Y con esto concluyo. Como ustedes han podido ver, nuestra experiencia de diferente, por un lado, una declaración viendo a lo que nos íbamos a enfrentar en COVID y las consecuencias de derechos humanos, y por otro lado, un caso concreto, en unos dramas grandes que vimos en nuestra región, que son los migrantes y cómo darle, en este contexto COVID, una protección especial. Muchas gracias.
Thank you, Pablo, once again for your presentation. So now this is the time for a small recap, for summary remarks, and I would like to ask my colleague, Professor Landa, please.
Thank you. Voy a hablar ahora en español porque me parece importante que en esta mesa dedicada a la jurisdicción constitucional, Estado de Derecho, durante el estado de emergencia, hayamos podido tener la oportunidad de escuchar reflexiones desde los países de Europa Central y también de la perspectiva latinoamericana. Y creo que esta perspectiva, si la podemos ver en un punto de vista comparado, no es usual, ¿no?, que se realice, pero creo yo que hay elementos comunes desde que los valores en los procesos democráticos que han habido en América Latina y en Europa del Este han confluido en que la persona humana y su dignidad es el fin supremo de la sociedad y del Estado, y en función de ello, los acontecimientos que hemos analizado sobre el COVID-19 han tenido respuestas desde el Estado democráticos, de sus órganos jurisdiccionales, con variantes definitivamente que ponen en evidencia que en democracia también hay fórmulas pluralistas de atender los problemas, evidentemente que podrán ser unas más exitosas o no, pero cada realidad nos permite conocer los resultados en función de los principios de protección de los derechos humanos y del equilibrio de poderes, que han sido los principios fundadores de la Asociación Mundial del Derecho, ¿no?, y que se ratifica en este Congreso y en esta mesa con los análisis presentados, ¿no? Solamente quería dar esas palabras de agradecimiento y dejo en uso la palabra.
Thank you so much. That's all as regards us. This is maybe the time for discussion, for open discussion after first and second panel together. We have the time for open discussion, for open floors. If not, so thank you once again. Thank you very much for all people. Oh, yes, please.
Thank you very much, and first of all, welcome to Colombia, Barranquilla, La Puerta de Oro. Well, my question is headed not so much towards the emergency state, but is rather focused towards the jurisdictional, the constitutional jurisdiction. In Colombia, we've only had the Tribunal Court for the last 30 years, meaning that many of the rights that we, the Colombians, nowadays have are thanks to the constitutional jurisdiction. For example, the exceptions that we have for the abortions for not to be legal were given by our constitutional court, also the marriage for same-sex couples were also given by the Constitutional Court, or their right to apply euthanasia on patients that are close to dying or are in very much pain. My question is headed towards all those, well, I was wondering what was the case in the jurisdictional courts of your countries when it comes to the progression of rights, since in Colombia most of these rights come from a jurisdictional via, since the Congress often cannot provide these rights that the population needs. So my question is headed towards what is the case in your countries as to the progression of rights and the role that the Constitutional Court has played in the progression of these rights. Thank you very much.
Maybe different questions, please. Maybe other colleagues. So, if not, maybe Alexander, maybe you.
Thank you very much. I can try. I can speak maybe about Central Europe. This, after, let's say, the revolutionary movement after 1989 or starting by 1990. Yes, the idea of the protection of constitutionality, I would start maybe by Czechoslovakia, because it was present in 1920. A couple of months finally before Austria has introduced the Constitutional Court based on Hans Kelsen's concepts. So these constitutional courts have been very weak in practice because of the time. The 20s and the situation after World War I was not in favor of, again, like after the French Revolution. It's a different angle, of course, but not in favor of protection of constitutionality, although constitutional courts have been established. Then there were no decisions. For example, this matters. There were no decisions, also not coming from the Czechoslovakian court, and it's based on history of the Supreme Court. It shows that the Supreme Administrative Court, which was introduced the same time, based on some German, Austrian, also French ideas, Supreme Administrative Court, was much better in protecting some administrative decision in favor of, let's say, basic rights. So this was the story that time. Then it was towards World War II, so this was the end of, let's say, liberalism also in thought, and it was another dictatorship already in the Soviet Union, and Germany was the second experience, very bad. And then via Germany, if we don't count with the Supreme Court of the United States, but this Supreme Court of the United States was based only on one decisive competence, constitutional review. This is the original idea, constitutional review. Not to forget Brazil, because it's the second oldest constitutional court. So also with, we have introduced after Second World War by the German Constitutional Court very strong constitutional complaint, which was very, very important, because via constitutional complaint introducing, it came a stronger protection of fundamental rights and freedoms. In fact, this is a matter of fact. So this was like, yes, in the Spanish world we know from the history, amparo was also very important in other courts, let's say, and the development of it. But this was a breakthrough, and let's say Article 1 of the basic law, Grundgesetz of Germany, human dignity is something to worth of as a value to protect, coming first. So this was the story after World War II, but because of division of the world and Europe, so Central Europe was under the rule of the Soviet Union, so was no need for protecting the constitution. Formally, everything was perfect. And I'm keeping it short. After the break I mentioned, 1989 and 1990, it's a bit of simplification, but then the countries in Central Europe, first of all, maybe based also on some traditions, like, let's say, after the division, Czech Republic, Slovak Republic, but also Poland with another tradition, important tradition, but also, let's say, some Hungarian movements, and I'm sorry, I will finish soon. I would like to say that we have thought about this tradition, that we already had something before or between World War I and II, like a constitutional court or real constitutional court, although it sounds formal. And then then you have asked about experience, like Colombia, when it has introduced the constitutional court and protection of constitutionality. I know a little bit that it was a very good thing to introduce a constitutional court because of protecting fundamental rights and freedom. This is a clear progress, and this is something complying with the rule of law. So this was the first year. 10 years was euphoria. It was euphoric. But now it comes, and it still goes on, a decline and the crisis of the idea, and for some reasons, but I would say one sentence, because politicians, and it's after election, it was Poland, the matter of quarrel with the European rule of law and the European courts. So these politicians and the legislative is seeing that it's an enemy, the constitutional court, because it will overrule sometimes, let's say, maybe bad ideas, going in favor of the ruling, let's say, parties or the man in the rule of law. So this is, in brief, just the history. It's a crisis at the moment, and difficulties in the relationship between legislative or the constituent and judiciary. Sorry.
Thank you, Alexander, for your answering. So we have to finish, yes? Sorry, I would like to say a few words concerning the Polish situation, but we haven't got the free time. But generally, I would like to support the answering of my colleague Alexander Bröstl, because according to my opinion, the situation in the Central Europe countries is very similar. This is the step down in the field of democracy and in the field of the constitutional democracy. Very, very briefly. Thank you once again for your presentations, for your attendance. Once again, thank you for Adenauer Foundation, and see you next time. I have very, very good impression after our meeting here. Thank you once again.